Good morning, everyone. This hearing is in the matter of case number CFI 030-2023 and is being held by way of video conference before Justice Andrew Moran. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimants are represented by Al Haya Al Nubi advocates and legal consultants. Lead counsel is Asha Bajoy. The defendants are self-represented, and for today, lead counsel for these proceedings is Mr. Santu Ghosh.
Yes, well, good morning, both of you, Ms. Bajoy. Do I pronounce that correctly, Bajoy?
Yes, Your Honor, it's Bajoy.
Right. And Mr. Ghosh.
Good morning.
Good morning to you both. There are a number of matters which are concerning me about this case that I want to raise with you to begin with, as to whether it ought to be proceeding to trial as presently fixed at the end of May. I should just alert you to the fact that due to the holiday week last week and some technical difficulties that I encountered with the CMS system that we all use, which normally works perfectly and without difficulty. Unfortunately, in this case, there are a number of problems. I'm not blaming anyone at all for these problems. These things do arise with the technical wizardry that we are now obliged to use in litigation and arbitration across the world. There are actually as well some problems in the performance of the parties, I have to say, on the approach to this pre-trial review, in that unless I have missed it because of these technical difficulties, it does not appear that the parties have complied with RDC 2675 regarding the provision to the court of a timetable for trial, in effect the vital picture of an agreed timetable as to how this hearing is going to proceed. I'll stop there for a moment and ask the question, have you conferred and have you complied, unknown to me, with RDC 26.75? I'll ask you first, Ms. Bajoy.
Yeah, thank you, Your Honor. Yes, I do admit that there has been some delay in uploading the timetable, but as on today, there is an agreed version of the trial timetable that is uploaded in the bundle, Your Honor.
Right, well, when was that uploaded? Because it wasn't there last night when I went to bed, because I've been working on this case all weekend for reasons which I'll explain in a moment. So there is now on the bundle, is there, an agreed timetable that you have prepared, and it is there for my consideration?
Yes, Your Honor. It is under section W.
Let me
if Your Honor has access to the portal.
Yes, I do have access to the portal now. Give me a second. I'll keep you on one screen. I have work with 3 screens, so let me just look at this. Well, I'll while I'm talking to you, I will get it up, and I'll explain to you what the other difficulties are that may also have been resolved. I do not know. The bundle is incomplete. There are significant materials that I only know about because of the diligence of a law clerk that I have, who has ploughed through the events section on the case management system, gone back to the original filings. For example, on the bundle that I was working with, specifically filed for this hearing, the statement of Phoebe Leah Tucker is not in the bundle. It is in the events folder, and I have it and I have read it. But as I say, not because of the diligence of the parties in uploading it and filing it in the bundle, unless again you tell me that is wrong and it has been filed in the bundle or that there is a new bundle. But it was not there. And there are other documents as well. I don't know whether they're relevant or not, that are present in the events section of the case management system for this case, but are not present in the bundle. I have been hobbled in preparation for this hearing and case by technical difficulties I encountered last week in accessing the materials in the first place through the CMS. I normally like to work with a PDF copy of the bundle, preferably individual PDFs of the crucial documents, because a nearly 3,000-page bundle in a single PDF is beyond the ability of almost every document management software that I have ever encountered. I use Adobe Acrobat Pro for your information, and I will be requiring a PDF bundle of the relevant individual documents in due course for this hearing, or at least a bundle uploaded to the CMS system that corresponds to that sort of PDF assembly of documents, because only by that means can one conduct a remote electronic trial. 3,000 pages of documents, nearly 2,800 and something to be precise, and there may be more, you're telling me there's more in the bundle, would fill up this room that I'm presently working in. I'm actually in the UK at the moment, but I work all over the world, so it's critical for me to have an effective working electronic bundle that I manipulate, annotate, highlight, and use in the conduct of a trial. And that is the claimant's responsibility, ultimately, first off, with agreement, of course, with the defendants. So you need to be aware of those difficulties last week. Despite them, I think we've overcome them. I was provided with a substantial PDF bundle on Saturday. One of the court staff, although the courts are closed, as you know, from all of last week, one of the court staff, well, two of them together, working together, helpfully provided me with a PDF bundle on Saturday, but it's not the full bundle. They did the best they could. There are problems with some of the documents in the bundle. And what, to use the technical expression that the head of IT used to me, he managed to download a PDF from the bundle, from, as he put it, the back end of the bundle. I'm not quite sure exactly what that means technically, but I ended up getting all of the relevant documents, I think, or most of them, in order to prepare for this pre-trial review, where the trial is presently listed for the end of May. So those are the technical difficulties that I have encountered that you need to be aware of, but I think they have all been overcome. You should know of them because I may say things in what I'm about to raise with you that are in fact incorrect. If I do so, it is because I have not had the proper assistance from the parties in the preparation of the bundle, or their pre-trial agreed timetable, which is the picture of the trial that I should have in order to consider it and determine whether other directions are required. So that's the first section of things I want to say to you. The second section is perhaps altogether more important for the proper case management of this set of proceedings in CFI 030. I'll refer to them by their number. But as you will both be aware, I have also read and I believe understood all of the references to two other sets of proceedings, separate sets of proceedings in this litigation. CFI 6, is it? Yes, CFI 006 of 2023, which was an injunction application. But more importantly, CFI 019, which is an application to file a derivative action on the part of the defendants to these proceedings as claimants in those proceedings. And as I understand it from information received as recently as this morning, at 6 o'clock this morning here in the UK, leave to file a derivative action has been granted, but that is presently subject to an appeal, and that matter is being handled by the Deputy Chief Justice, who is unfortunately presently on leave. Otherwise, I would be discussing these cases with him. The concern I have is this. As you all well know, I have a duty to manage these cases, or I have a duty to manage this particular case, CF 030, which has been allocated to me at present, fairly and efficiently in order to achieve the overriding objective. But I cannot do that in isolation from the case CFI 019, particularly in the circumstances of these cases, where, as has been pointed out and as I have seen, the claim in CF 030 is a virtual facsimile of the defence in CFI 019. And, wait a minute, vice versa, the defence in these proceedings, CFI 030, has a raft of allegations which look to me, I haven't seen it because I'm not seized of it, which look to me to be the foundation of the application and prospective claim in CFI 019. That's the first difficulty. So it does not appear to me that any consideration has yet been given to the possibility that the court in this case, in exercise of its powers of case management and in conjunction with the management of CFI-019, the court might well consider making orders under RDC 4.2, 7 and 8 to consolidate proceedings or to try 2 or more claims on the same occasion. Let me tell you what is concerning me. As I look at the allegations which are contained first in the pleadings on both sides, there is a massive raft of claim and counterclaim on both sides, which embraces not just the agreed issues which were presented to the managing judge in this case as a fait accompli. They embrace everything, every argument, every dispute about every piece of conduct in the formation of this joint venture activity and use of the first claimant company as the joint venture vehicle, and they contain everything that is now being alleged in CFI-019 as the basis of the claim for a derivative action for what I understand to be, though I've not seen it, shareholder prejudice alleged against the claimants in this case as defendants in the other case. And it's as plain as a pikestaff to me that if I were to proceed to trial with this case, and CFI 019 was to sail on its way alone, separately, there is a manifest risk of 2 different judges coming to different conclusions on issues of fact and law, common issues of fact and law, and we have precisely that which these forms of orders that I've just referred to in RDC 4.2 are designed to avoid. And I cannot allow that to happen. It would be neglectful of my duty to do so. Let me give you an example. There is a defamation claim in these proceedings. That defamation claim is founded on allegations made about corporate mismanagement, which are precisely the same grounds for the derivative claim which it is sought to pursue. And I am going to have to judge, although it's not properly pleaded, either the claim in defamation or the defense in defamation, but I presume the defense in defamation, though not properly pleaded, is a defense of justification or qualified privilege, or both. And therefore, in this case, would I not have to judge whether the complaints that the defendants were making about the conduct of the management of the claimant company in these proceedings were true? And is that not the same issue that arises in the derivative action, which at the moment, until an appeal is allowed, unless an appeal were allowed, are going to be heard in that case, CFI 019. So it seems to me that insufficient thought has been given to whether this case ought to proceed to trial before we know where we are going with CFI 019. At the moment, an appeal is pending. I'm informed that the Deputy Chief Justice is likely to deal with that on his return from leave. So that is not far in the future. And we will know then whether the derivative action is going to proceed or not. Let me say this to you as well, that if, this is really the third section of things that I would say to you, as a prelude to determining whether I can proceed to case manage this case by virtue of this pre-trial review to trial at the end of May, I can tell you that my first direction, if I was to allow this matter to proceed to trial today, would be to send you both away to completely re-amend your pleadings to correspond to the issues that are for trial in this case by way of agreement, and to completely re-amend all the statements that you have presently filed, which are a scattergun of allegations this way and that, and responses this way and that, going far beyond the issues, but necessarily dealing with matters that do arise, as I've just illustrated by the defamation claim, in CFI 019. So that would be a task you would have to perform in the next 7 days. That's what I would give you if this matter was going to proceed to trial. But then, when one steps back from that kind of direction, it only reinforces the view that I have provisionally taken that this matter should not proceed to trial until we know what is happening with CFI 019, until I and the Deputy Chief Justice can confer, until separately, because the cases are being managed separately at the moment, we decide whether the cases should be, each of them, subject to orders for consolidation or to be heard together by the same judge, in order to avoid the peril of inconsistent findings. I haven't even mentioned the overriding objective of efficiency of trial. I ask you both, are we going to go through 4 or 5 days of trial on this case with the morass of allegations, counter-allegations and defences that are presently contained in the pleadings in this case and the witness statements, hear them all, have me determine them all, and then on another occasion, 6 months down the track, have another trial before the Deputy Chief Justice on a derivative claim dealing with more or less precisely the same allegations and evidence in an improper prejudice claim? It's a nonsense. and it is completely contrary, in my view, to the overriding objective. It does not serve the overriding objective to contemplate such a scenario. So I'm sorry this probably comes as a bombshell to you, but I have read very, very deeply into these cases, despite being hobbled, as I've explained to you, by technical and holiday matters, not being able to get to the bottom of things other than by dint, as I say, of the diligence of my law clerk, who I fortunately have in my other life as an arbitrator, who's assisted me in this case in ploughing through the materials. So what I'm going to do, having explained all of that to you, I will ask you both now whether you would like some time to reflect. I'll take a break for 15 or 20 minutes, so you can confer with whoever you confer with on these matters. I've outlined what I'm thinking. You may persuade me to the contrary. I very much doubt it, but I will listen to you if you wish to try and persuade me to adopt another course. But for the moment, what I'm considering is adjourning this pre-trial review, waiting until I'm able to speak to the Deputy Chief Justice, or waiting for his decision on the appeal which has been raised by the claimant to the order granting permission for a derivative action to be brought, and to consider a joint approach to case management of these two actions if it is necessary. If, for example, the appeal was allowed and permission to bring a derivative action was refused, then there is a raft of material presently in the pleadings in this case and in the statements that would have to be taken out. It's nothing to do with the issues which you've agreed arise in this case. If, on the other hand, the appeal is dismissed and there is to be a derivative action, then all is in play. I'll put it as simply as that. All is in play. And then the case management would be rather different than for a single part of this shareholders dispute, corporate dispute, call it what you will, overall, would be determined. So I'm going to break for 15 to 20 minutes. You can ask me how long you want, and I'll come back and hear any submissions you wish to make. Otherwise, I propose to adjourn the matter. It may involve an adjournment of the trial. That depends on the outcome of the appeal and my discussions with the Deputy Chief Justice on case management of these matters. I will not be making that decision today for obvious reasons. And it is unfortunate that you will have to proceed at the moment on the basis that the trial is going to proceed if I adjourn the matter until I can resolve these difficulties of case management. So we'll adjourn now. I'll give you both. How long do you want, Ms. Bejoy?
15 minutes would be a good enough time, Your Honor. Thank you.
And Mr. Ghosh?
Same, 15 minutes is fine.
Very well. I'll give you both 15 minutes, and therefore it's 25 past 7 here, 25 past 10 with you. Let's say we'll resume at 11:15. I'll give you a little bit of leeway. Time for me to have a cup of coffee, an early morning cup of coffee. Thank you both very much.
Thank you.
Thank you very much, Your Honor.
Then you can leave the hearing for now.
Thank you.
Hayley, are you still there?
Yes, Justice Moran, I'm here.
Okay. I don't know who else is present. I think
There are still external parties on the line.
External parties online. Can we go to a breakout room?
I can quickly set up a private Teams call. That's fine.
Yes, fine. Right. Can you hear me now?
Yes, Your Honor, we can hear you.
Right. Good. So I will start with you, Miss Bejoy. First of all, do you understand, I'm sure, and accept the concerns that I have? But what course do you submit I should take in the light of what I've told you?
Yeah. First of all, thank you so much, Your Honor, for I'm really grateful for your time explaining to me the complexities involved in the current trial. So I have had the chance to discuss this with my clients, and my clients are of the view that until the 019-2023 appeal is disposed of, they are willing to postpone the trial of 030, the current case. However, the only concern that has been highlighted to me is that as such, at the moment, we do not have a derivative claim. We only have an application to initiate a derivative claim. So the uncertainty that my clients would face in the event if the derivative claim is not pursued within a fixed or a considerable or a certain timeline, then the whole question of what would happen to this 030 claim is the question that has been highlighted to me. So in that regard, Your Honor, I would like to humbly request that when you discuss this matter with the Deputy Chief Justice, if there can be some kind of a consensus on whether a particular direction can be included in the order, which in the event that the appeal is dismissed, giving some directions to the applicant to initiate the derivative claim, that would be really, would make it more efficient so that, we could then explore the option of consolidating the proceedings.
Yes.
In that regard, also, Your Honor, Your Honor has been grateful in highlighting the other related matter, that is 006-2023. If Your Honor may have an opportunity to go through the order, we had indeed challenged the injunction application, and unfortunately, we have been now subject to an injunction, which is an indefinite injunction. And again, the uncertainty is whether or not are they going to, because the common law principle is that injunction is only an interim relief, and there has to be a firm undertaking given to the court to initiate the claim. And that step has not been initiated even in 006 of 2023. And because of that, we are now facing an injunction. And our appeal has also been dismissed by the court. So looking at that background, considering that as the context, I would humbly request that if there is an outcome in 019, that is to allow the application to proceed with the derivative claim, if there can be some direction given to the applicant to initiate the claim within certain timeline, that would resolve the whole uncertainty here on when and how the court will have an opportunity to hear the parties and to resolve the disputes between them.
Very well. That's very helpful. Thank you, Ms. Bejoy. I can say immediately, because it cannot possibly be the subject of any dispute, that if the appeal is dismissed and that the permission to pursue a derivative action is upheld, then there will be directions for the bringing of those proceedings, a very tight timetable to bring all of these long outstanding matters to whatever final hearing is required. I have not been able to consider CFI 006 to any significant extent. I've only been able to consider CFI 019 because of the extent to which it is deployed or recounted is the better word, I think, in these proceedings. But I can assure both parties that there will be such directions as are necessary to bring all outstanding disputes between these parties to a determinative conclusion by whatever means are necessary. And as you say, that depends, first of all, on the outcome of the appeal. So thank you for that. Mr. Ghosh, do you have anything to say in objection to what has just been said or to the concerns that I have raised concerning how this matter should proceed?
No, I agree with you. I agree with Ms. Asha Bijay also that we should have a timeline by which my client will also have to file the derivative claim. Otherwise, that would create such a ruckus, and it will be totally injustice for the claimants here. So we agree that this matter may be adjourned, and subject to the decision of the permission to appeal, we will obviously proceed with the derivative claim unfair prejudice. And then obviously things will fall into place, and both the matters can be merged together, consolidated, and your lordship can proceed accordingly.
Very well. Well, that's very helpful from both of you. The only thing that I'm considering further as a direction, if the appeal was allowed and there was to be no derivative action, then there is the matter of CFI 006. I cannot make any comment in relation to that. That case is not assigned to me. It may be assigned to me to look at, to consider in conjunction with all three sets of proceedings. That's not for me to determine. But could I just ask this question of you, I think, Ms. Bejoy, because it's the matter that you've raised as a concern. You say at the moment there is an injunction. I wasn't able to track down the injunction order in the bundles I had over the weekend, because I should mention this to you, Mr. Ghosh, the referencing in the amended defense to the exhibits which include the injunction order is completely awry. It's all inaccurate. That when you say annexure, I can't remember which one it was, maybe 5, to the defence is the injunction. It is not, and I've not been able to track it down. I'm sure my assistant will identify it for me after this hearing. But this is the question I want to ask. In a nutshell, Ms. Bejoy, what does the injunction restrain?
Yes, Your Honor. The injunction restrains the shareholders of Sam Precious Metal from transferring their assets, including their shares.
Transferring all assets?
All assets. Yes, any assets. And the interesting thing is the injunction is imposed on the shareholder, not on the entity.
Right.
So why should the shareholder be prejudiced for a cause of action that's been brought against the entity?
Right. Well, don't argue the case.
yeah. Apologize, Your Honor.
Don't argue the case. You've appealed the decision, and the appeal has been rejected. But that does not prevent, as you're obviously well aware, the making of an application to review an injunction order in the light of new circumstances, and obviously new circumstances might be the determination of these other outstanding claims, CF 019 and CF 030. So that is something that is for consideration down the track. I just wanted to know exactly what the injunction restrained for present purposes. I will obviously look at that insofar as it is relevant to my case management of CFI 030. Obviously, I'm sure the Deputy Chief Justice will have that in mind as well in his case management of CFI 019. So what I propose to do, therefore, is to adjourn this pre-trial review. And I was just about to say the one matter that is concerning me is whether there is any prospect of saving the trial date, which is at the end of May, depending on the outcome of the appeal, as we've all agreed must be resolved. And I have already outlined to you that if the appeal was allowed and there is to be no derivative action, then what is presently before the court in CFI 030 goes way beyond the issues that you have agreed should be tried in CFI 030. Those issues which are listed in the case management directions and order of His Excellency Justice Nasir Al-Nasir of the, just looking for the date, it was the 9th of August last year, reissued on the 28th of September last year. Question is whether I should give a I'm looking for the right word to describe it, a contingent direction that you both go away and work on the pleadings and the statements to put them in a proper order to address the issues which you have agreed are for trial, including the bundle as well. Because, as I say, as things presently appear, every allegation under the sun that is made in dispute between these parties is contained in these pleadings, which go far beyond what is necessary for the determination of the issues you have agreed should be tried in CFI 030. Now, that could be very wasteful. That could be very wasteful indeed of time and effort. So I'm raising it with you in case you wish to take a position on it. But my present thinking as I talk it out with you is that it would not be efficient case management to require you to be doing all of that in circumstances where we do not know the shape of the proceedings that may ultimately be conducted by a single judge to determine all of the disputes that presently exist between these parties. So unless you persuade me that you want to go away and do all of that, I'm having raised it, I'm not minded to make the order that you do it at this stage until we know what is happening with CFI 019. Do you have any observations on that, Ms. Bejoy, first of all?
Yes, Your Honor. So I would definitely take instructions with my solicitors that they will streamline the pleadings in line with the issues that are already framed in the CMC order, because I believe most of it is probably because the defendant is a party in person, and maybe little direction on how a pleading is to be put in place. Perhaps that could be the reason why everything has been included in the statement of defense and the reply.
Yes.
So I would definitely work with the clients and the solicitors in terms of streamlining the statement of claim, the statement of case in this case,
Yes.
to align it with the issues that are framed in this particular case. Also in that regard, Your Honor, I just would like to, I'm grateful that Your Honor has highlighted about the statement of Ms. Phoebe. Although Ms. Phoebe has filed statements as part of the pleadings in a reply, what I have come across is that there is no statement at the stage of evidence submitted by Ms. Phoebe. And all of the statements, the statement of defense and the rejoinder, it's all signed by Ms. Phoebe. And how do we establish these facts unless Ms. Phoebe files a witness statement and comes and give oral evidence? I would be grateful if Your Honor could give me some directions on that regard, because I see that as per RDC 29.9, Your Honor has wide powers when it comes to case management.
Yes, just, I'm sorry, I'm perhaps not understanding you correctly there. The statement of, this might explain why it's not in the bundle. I don't know. The statement, 29 point, which rule did you refer to?
29.9, if I may read it loud, the court may control the evidence by giving directions as to, 1, the issues on which it requires evidence, which we have already discussed, Your Honor, and we are fully in agreement with you that we will streamline the pleadings to go with the issues. Now, point number 2, the nature of evidence which it requires to decide those issues. And third, the way in which the evidence is to be placed before the court. Yes. For point number 2 and 3, Your Honor, the fact is, Ms. Phoebe has signed the statement of defense and the reply to the statement of defense, the reply to the rejoinder to the statement of defense. But if Your Honor were to look at the evidence submitted, there is no statement, witness statement submitted by Ms. Phoebe under the statement of truth. And Ms. Phoebe is not coming in as a witness to give evidence. Now, what would be the status of the evidence that has come in the statement of case? Can we just call it as a hearsay or a case to be established? Or should we give directions for Ms. Phoebe to come and give evidence? Because unless Ms. Phoebe is available to give oral evidence, how do we establish those facts? Because if you look at the statements, we only have a statement from Mr. Shakti and the other gentleman who is employed by Snyder. But I believe all of the submissions has come from Ms. Phoebe, and Ms. Phoebe has not filed a statement, witness statement, or neither is she coming in as a witness to be examined by us.
Well, just clarify this for me. There is a statement. As I say, it was found in the events section of the CMS from Phoebe Tucker. Let me just try and open that. Give me 1 second.
Yes, a pleasure, Your Honor.
So the statement I'm looking at, though it's not in the bundle, is a reply witness statement by Phoebe Tucker for the defendant number 1. It is headed as being in these proceedings. It has various exhibits. It responds to the witness statement of Mr. Sami, if I can refer to him shortly as that, and opposing the witness statement of claimant number 2. This, when I read it, seems to be in response to an application that the proceedings be held confidentially, which was rejected. So she deals with that. And then she also deals with the the injunction. And then the substantial part of her statement is to deal with a purported settlement effected by Mr. Dhruva Acharya. This is paragraph 6 in particular. And then that really is the substance of the statement. But you're saying because she she has signed the pleadings in the case, she ought to be directed to give evidence to verify those pleadings. Just remind me, has she appended a statement of truth to the pleadings?
May I, Your Lordship, point this out?
I'm sorry, Mr. Ghosh, I'm not hearing you. What did you say?
Can you hear me now?
Yes, I can. Yeah.
May I point this out? If I look in the bundle, it's tab C, where the defendants have filed a defense without counterclaim. The defense to amended claim, that is at page 330.
Wait a minute, let me
This
get...
defense, yeah.
So I'm looking at
Tab C.
tab C, yes, I have that. And which...
Defense without counterclaim, page 330. Defense to amended claim, that's the final one.
Is that section 4?
Yeah, section 4.
Right.
So this has been
pause
signed and...
Pause a moment.
Yeah.
I've actually printed this version off, so... So this is actually verified by Mr. Chauhan, not by Mr. Tucker. Yeah.
Correct. And Mr. Chauhan is a witness in this case.
Yes.
But I will just look into what Ms. Asha had said regarding Phoebe's response to something about Dhruv Acharya. I'll look into it and check if it is something which is related to this case or any particular application which was filed by the claimant. Because the other application regarding confidentiality, that is no more relevant. And Phoebe just filed a witness statement in response to the claimant number 2's witness statement. So I don't believe that has any relevance to the defense to this claim or to the witness statements regarding the evidence.
Yes, well, this is precisely the point I was making. There's an awful lot about this in the bundle and in the witness statements that have been filed in this claim. This is the sort of thing that led me to make the comment that there needs to be a very substantial filleting of the materials that are presently before the case, before the court. Ms. Bejoy, the defence is verified by the witness of the relevant facts, Mr. Chauhan. So I'm not understanding precisely why you're seeking a direction that Ms. Phoebe Tucker should make a statement. I can't direct that she make a statement about anything. It's for the defendant to call such witnesses as it wants to call to defend itself in these proceedings. Now I'm beginning to understand why the statement of Phoebe Tucker is not in the bundle, because it doesn't go to relevant issues that you have agreed for trial. So what are you still pursuing this application about Ms. Tucker, and is it something that really ought to be considered when the shape of the case is fully known?
Apologize for the confusion, Your Honor. Yes, I would like to go back to my solicitors in that regard and take instructions, because I was under the impression that there is a statement. An application to produce a documentation was submitted by Phoebe, is what I understand from the instructions that I have received. So on that basis, can we request for Ms. Phoebe also to be examined, is what we would want to explore. But Your Honor, I would, if Your Honor may please allow me, while we streamline the pleadings, can we also get back to you on the list of witnesses and how do we want to pursue arriving at the list of witnesses who would be appearing to give oral evidence?
Yes, well, you could make whatever applications you like in relation to those powers under RDC 29.9 that you've drawn to my attention, as may be appropriate when you have reviewed the pleadings and the witness statements in the case. And I'll make no further comment or give no further indication in relation to that until I receive any application that may be forthcoming down the track. So I think on that basis, having heard you both, all I will do today is simply make an order adjourning this pre-trial review. I will not vacate the trial date for the present. But I have to say it does look unlikely that the trial dates can be preserved, as we may not know until the appeal is determined, and I don't know when that may be, what the shape of the case will be. And only at that stage could I give definitive directions for CF-030 and or the Deputy Chief Justice or me or him alone give directions for CF-019 or both cases together. There's a number of permutations that may arise there. So I'm simply going to adjourn the P-trial review to be relisted on a date to be directed by the court in due course. I will add after consultation with the parties concerning your availability.
Obliged, Your Honor.
Very well.
Thank you, Your Honor. Obliged.
I thank you both for your understanding of the difficulties which are, I think you both now recognize, clearly apparent in dealing with all of these matters efficiently and in accordance with the overriding objective. Thank you for your approach to this hearing this morning. And I will now conclude the hearing and wish you a good day wherever you may be. Of course, we barely know where everyone is these days in this virtual world that we live in, but there we go. Good day to you both. Thank you.